सर नाम बोलो।
अच्छा बेटा, कंफर्टेबल हो पहले तो?
यस सर। हाँ।
श्योर? थोड़ा एक बार एटमॉस्फेयर से यूज्ड हो जाओ।
एकदम प्रोफेसर जैसा लग रहा है।
प्रोफेसर जैसा लग रहा ना? हाँ ठीक है। तो अच्छी फीलिंग आ रही है, खराब आ रही है?
बहुत अच्छी।
अच्छी आ रही है, ठीक है। आ, देखो, बोलते हैं लॉ याद नहीं हो सकता। लॉ याद हो पा रहे कि नहीं हो पा रहे, पहले इससे स्टार्ट करो। आप हो पा रहे लॉ याद?
यस रोज रिवीजन करते हैं तो हो जाता है। आज सुबह ही मैंने वो आप बोलते थे ना नोट करना इंडेक्स में, तो आज सुबह ही किया तो वो 6.5 मिनट में पूरा हो गया।
ओके। तो सबसे पहले आप नाम बताइए अपना, और आज आप क्या रिवाइज कराने वाले हैं वो बताइएगा। पूरा चैप्टर आपको रिवाइज कराना है। चलो स्टार्ट करो।
Good evening, all. My name is Ethan Chawda, and I'm going to revise Articles of Association. As per Section 2, Clause 5, articles means articles of association of a company as originally framed or as altered from time to time in pursuance of this Act or any other previous company law. The Articles of Association are the internal rules and regulations governed to regulate the internal management of a company. The articles contain regulation for the internal management of the company, and it shall contain such matters as may be prescribed. However, it may contain such matters as may be considered necessary for its management. As per Section 5, the articles may contain provision for entrenchment. In this case, specified provisions may be altered only if conditions or procedures which are more restrictive than special resolution are complied with. The provision of entrenchment can be made in the following manner: either at the time of formation of company or by amendment of articles, with the consent of all members in case of private company, and by passing a special resolution in case of a public company. Where a company has a provision for entrenchment, the company shall give notice of such a provision to the registrar. The articles shall be specified in such forms as prescribed in Schedule 1. For company limited by shares in Table F, in company limited by guarantee, having share capital, Table G, in a guarantee company not having share capital, Table H, and unlimited company having share capital, Table I, and unlimited company not having share capital, Table J. A company may adopt all or any of the regulations as contained in the model articles applicable to such company. If the duly registered articles of a company do not exclude or modify the regulations contained in the model articles, those regulations shall automatically apply to it. Now, as per Section 6, where there is a conflict between the Act and the provisions and the any resolution, agreement, articles, or memorandum, the Act shall prevail, and such article, memorandum, resolution, or agreement shall be void. As per the provision for alteration of articles are given in Section 14 and 15. Every company shall have the power to alter its articles. A company cannot divest itself from these powers, as highlighted in the case law Andrews versus Gas Meter Company. Where if a company can convert from private company to public company or vice versa. For this, a special resolution has to pass. Where a private company has deleted 3 restrictions as prescribed in Section 2, Clause 68, it shall cease to be a private company. And where a public company wants to convert to a private company, approval from central government shall be required. Every alteration and a copy of central government order together with printed company of altered articles shall be filed with registrar within 15 days, and any of the alterations duly registered with the ROC shall be valid as if it were originally contained in the articles. As per Section 15, every alteration made in the memorandum or articles shall be noted in every copy of memorandum or articles. Now, as per section 17, the company shall, on request by member, send the copies of following documents to the member on payment of prescribed fees, which is a memorandum, article, every resolution and agreement as referred in section 117. Now there are following restrictions of articles, which are: the articles shall not be inconsistent with the act. It should not be inconsistent with the act, either of this act or any previous company law. It must not be illegal. It must not be inflict hardship on members, not be fraud on members without corresponding benefit to the company. For conversion of public to private company, previous central government approval is required. It shall not conflict with the memorandum, and it should not exceed the powers of memorandum. And if it does so, it shall be wholly void and inoperative. And in that case, the memorandum shall prevail. And it should not result in exclusion of member.
एक्सलेंट आंसर,
Thank you, sir.
बहुत बढ़िया बेटा। थोड़ा सा कहाँ मिस हो गया था? हाँ, वो जो आप शुरुआत में जो इंट्रोडक्शन बता रहे थे ना आर्टिकल्स के बारे में, तो सेक्शन 5 के जो शुरू के 2 पॉइंट है वो आपने पहले बोल दिया था, इंट्रेंचमेंट से आपने सेक्शन 5 स्टार्ट किया था। बाकी एक्सीलेंट, मतलब वो भले उधर बोल दिया आपने लेकिन कवर पूरा किया। एक्सीलेंट, बहुत बढ़िया, एक्सीलेंट आंसर।